Hello, everyone. Today we have part 4 out of 5 of filing a suit to perfect the lien in Tennessee. And today we have, of course, Bryan Thomas, who's going to continue on with our program. I'm Ariella Wagner, the founder of SunRay Construction Solutions. And Bryan, go ahead. Let's get started on our part 4 out of 10.
Sure, no problem, Ariel. Hope everyone out there is doing well this morning. I would encourage questions along the way if you have any, or I'm happy to take them on follow-up emails. Where we are today is we're to the point of perfecting the lien. Before we get into that, I just wanted to hopefully remind everyone that this is a multi-part series. We're going throughout the year and advancing session by session. So the rest of the sessions are here. If you get them on your calendar, we're glad for you to join us. But where I wanted to start today was where we were. And let's make sure that we all start at the same place. Where do lien rights, or what lien rights do you generally have in Tennessee? And we've talked about in Tennessee there being the difference between remote contractors and prime contractors. A prime contractor being anyone that has a contract with an owner, a remote contractor with anyone having a contract with anybody but the owner. Different filing requirements for both. That in Tennessee, we're pretty wide open. We let liens be filed and secure any payment really for an improvement and an improvement to real property, including leaseholds, as well as other property interests. But that lien is going to secure the contract price. It's not going to get interest. It's not going to get attorney's fees. So that's where we start. That's the basics of Tennessee lien law. Now, we got into how do you actually preserve those rights? What steps do you have to take? And we went through the prime contractor, starting with the notice of lien. Then we said you had to perfect the lien. And that's what we're going to talk about today. And so we're in that second step for a prime contractor. On the remote contractor side, we talked about the step one, which was notice of non-payment, then the notice of lien. And we mentioned that you got to perfect the lien. And that perfection of the lien is where the prime contractor and remote contractors kind of come back together in a similar process. So that's where we are today. Now, the first question when we're talking about perfecting the lien. Now, you may say, well, that sounds like a fancy word. What is perfecting the lien? Well, perfecting the lien has multiple parts. Generally, most people are going to think of this as time to file the lawsuit. It's a little bit more nuanced than that, but let's go through it. So first of all, the timing. When do you have to perfect a lien? You have to perfect a lien as a prime contractor within 1 year or of completion or abandonment. As a remote contractor, it's a little easier. It's 90 days from the notice of lien. So it's easier to count. Now, I tell you that, and then I give you a lot of caveats here, because you've got to be cognizant of the fact that, yeah, you don't have to file a lawsuit as a prime contractor for a year. You don't have to file a lawsuit as a remote contractor for 90 days from the time that you put down your notice of lien. But you've got to be aware of some things. Number one, if you're on a project that stalls, meaning that there's no work being done on the project for 90 days. You typically see this in a situation where you've got problems with city permits or a funding issue where a project is at a complete standstill for more than 90 days. You've got to be aware that under Tennessee, that is going to be a deemed abandonment as of day number 1, not day number 91. So if you're sitting on a project that you've done some work, but it's been completely stalled, you need to think, I may need to think about my lien rights, because quite frankly, if you're a remote contractor, the job's been stalled for 92 days, you may already be out of your time to proceed with multiple steps as a remote contractor, particularly that notice of lien that's got to go first. That deemed abandonment language also applies to the prime in the context of perfecting the lien, the time to perfect the lien. So just be aware that that's there if you have a big pause in a project. The other thing you've got to be aware of when you're looking at these back-ending lien deadlines is I always ask the question, okay, when was the last work? And most lieners that I ask that question to, their immediate response is, well, I had a guy out there last week. And what I need to caution everyone on is there's a number of cases in Tennessee that essentially say if you're out there doing warranty work or final punch item, you may be past what was thought of as completion. The cases are not crystal clear, but they seem to go toward the concept of more substantial completion type concept rather than a final completion concept. Again, it's a little squishy in what the judiciary is doing with it. That said, be aware, and when you're counting lien deadlines, be conservative. If you got a substantial completion date, use that as the date that you calendar off of for when you both have to record your lien if you're a remote contractor, when you have to file or perfect the lien and file a lawsuit if you are the prime contractor. So the other things, and we mentioned these along the way in our earlier series, the lien enforcement demand. Prime contractors and remote contractors who have served notice of non-payments are going to receive a notice if somebody wants to limit the time in which a party can perfect their lien. And what this statute does is really, it's once you record a notice of lien, it gives a party who either owns the property or is upstream in privity of the lien or the ability to cut off the time period in which to actually perfect the lien, the attachment and the lawsuit. So if you receive a notice like this and you have a lien down, know that what I told you about the 90 days and the 1 year to start this slide may not be accurate. In fact, probably will not be accurate. It'll probably be limited to 60 days from the time you receive the notice. The other one that we've mentioned along the way is the notice of completion. You've got to be aware of this. It'll shorten the time frame to 10 days on a residential project and 30 days on a commercial project. Again, if you have a problem, you need to consider whether or not you really want to wait the full 1 year or the full 90 days to file a lawsuit. So I just sit those out there and to be cognizant of, to make you think, yeah, there's this deadline out there, but you may not want to wait the whole time because there are a number of factors that are also going on in the background and could be cutting off your lien rights, particularly if you miss a notice that comes in. So that's on perfecting the lien. That's when you have to do it. Let's talk a little bit more about how you do it. And I start with this slide. The reason I start with this slide is we're talking about what's called an attachment. And to think about liens, you got to take a step back and say, okay, what are we actually doing? And the whole purpose of a lien, particularly Tennessee or elsewhere, is you want to take the property and make sure that the property that you have improved can be sold to pay you for the improvements made. And the way that happens ultimately is an auction. So instead of suing somebody and saying, hey, you owe me some money, you're saying, I'm going to take your property and get paid from selling that property. So that's the concept of the lien. And to do that, Tennessee has what is considered an attachment or a writ of attachment process that ultimately ends up in the sale of a property. And the attachment, what it does is it takes and gives the court control of the property so the court can sell it if you are successful in the lawsuit that we'll talk about in just a minute. So this attachment step is the first thing that's necessary. And I've got on the screen right now what is the statutory language. And the statutory language is all built on seeking the issuance of an attachment. Now this gets pretty technical, and this is one of those areas where if you have a bigger lien, I would definitely suggest counsel helping you out. But the key is that the lawsuit side of this, or the third step of perfecting a lien, all starts with this attachment. And we've got some unique language in our statute regarding attachment. It used to be that if the property was not actually attached within the time periods we talked about, the 90 days for the remote or the 1 year for the prime, the lien was no good regardless of if you filed the lawsuit. That has changed based on a case in a section of our lien law, and that's what you're seeing here in number 3, that very last sentence. So as long as you are going forward and has given the court what they need, or the clerk what the clerk needs to issue the attachment, that is enough to comply with the timing requirement. Now, there's one rub when you start talking about this attachment and what you have to give the clerk. That is an open question. Before I get there, I wanted to show you, what does a writ of attachment actually look like in Tennessee? And I've put on the screen for you the one that is used in Davidson County, particularly from the Chancery Court. And you'll see right here, what it's doing is it's making you put down the information about the property, so the sheriff can go serve the attachment and actually get the property within the control of the court. What does that practically mean? Practically, it means giving somebody a piece of paper or stapling the writ on the property, or there's a couple other ways to do it. But here's what it looks like. Here's what the form is that has to be filled out and submitted to the clerk with the lawsuit to enable the clerk to move forward. Now, that's part of the equation on the attachment. The other part of the equation on the attachment is, if you're going to take an interest in someone's property and try to perfect it, particularly to put it in the jurisdiction of the court, you got to put a little skin in the game yourself. And what is required in Tennessee is a bond, an attachment bond, and that's a $1,000 bond, or for larger liens, it can be increased substantially. That's going to require some effort on the other side. You can start with a $1,000 lien. The question that remains open is whether or not a party who fills out a writ of attachment but does not provide a bond is timely or is not timely under the Tennessee 90-day and 1 year statute that we started this discussion with. So my advice, if you're gonna go to the step of perfecting the lien and filling out the writ of attachment, make sure that the bond, in conformance with what you're seeing on the screen here, is submitted to the clerk at the same time you submit the writ of attachment and the lawsuit. All right, so that moves us, when do we have to do it? How do we deal with the attachment and the attachment bond? To what about the lawsuit? Okay, so there's the main section of the statute are on the screen for you right now. Like many things in our lien laws, there is a separate section for prime contractors and remote contractors. What I wanted to first call your attention to is, in reality, the language is the exact same for prime contractors and remote contractors. The remote contractors just has a little additional language about what you can do with the parties that sit between the remote contractor and the owner of the property, and that's what you see in blue. But big takeaway from this slide is remotes and primes are under the same really obligation when it comes to filing the lawsuit. Now, where we have to start in Tennessee, because our court system is a little bit different than some other states, is where do you file the lawsuit? To have that discussion, I need to tell you a little bit about our court system. In Tennessee, we have circuit courts and chancery courts. Circuit courts, both of general jurisdiction. Circuit courts handle everything, including, in most cases, criminal dockets. That's not true in some counties, but generally speaking, a circuit court is going to also have a criminal docket. It's also going to be the appeals court for a number of the lower courts that are not considered, quote, of record. That's going to be general sessions. I'll get there in a minute. Some of your municipal courts, some of your juvenile courts, those type of things are all coming up through the circuit. And I tell you that to generally think of the circuit as having to deal with everything. And in that vein, some of your circuit court judges sometimes aren't going to get very excited about a civil lien. That may be good, it may be bad. That said, that's the circuit court. The chancery court essentially has the same jurisdiction on the civil side as the circuit court. Historically, there was certain things you had to put in chancery, certain things you had to put in circuit. Now, most of that is all blended together. So you can put a lien perfection action in either circuit court or chancery court. One thing that you don't see in chancery is the criminal docket. So beware that chancery courts may be more in tune to a civil lawsuit involving the perfectional lien. It's more what they do on a day-to-day basis. Again, whether that's good or bad for you depends on the specific circumstances of the lien that you are trying to enforce. The other option is the General Sessions Court. General Sessions Court in Tennessee allows, a lot of people would call it the small claims court. It is an option for a lien perfection action if the lien is less than $25,000. What I will caution you on as far as our General Sessions Court is if it is a disputed matter, you can get a decision in General Sessions Court, but you are still going to have to enforce it in a court of record, being a circuit or chancery court. So even if you go get a judgment in General Sessions, you've still got to go up before you can have the property sold. The General Sessions Court does not actually sell the property. Now, the other wrinkle there is even if you get a judgment in General Sessions, if it is a disputed matter, you start over at square one if either party wants to appeal the judgment. And back at square one, I mean literally at square one. Now, I say all that and I tell you that there's not a lot of procedure in General Sessions Court, but what I will tell you is General Sessions Court is quick justice. If two sides are at odds about a low number, you've had to perfect a lien, and you're suing on that lien, then sometimes at a number under 25,000, it makes sense for quick justice, and the General Sessions Court is an option there. I will tell you that you're not required, and many people don't have counsel in the General Sessions Court. If you are an entity, you are going to need it wherever you are. But that said, General Sessions Court, again, a good alternative for some small liens. Any of them work under the lien statute. I will just tell you that if you're going to General Sessions, you do need to check back. We've got a specific statute about what you have to file in the circuit court or the chancery court if you're going to General Sessions. There's just some additional notice requirements. Now, the other thing I will tell you as far as which court, you've also got to consider that Tennessee has a statute that allows you to jump into a case if someone else is already trying to perfect a lien on a certain piece of property that you are also trying to lien. So if there's an ongoing case, you can just jump into that case. It also says, hey, if there's multiple cases, we are going to require them all to be consolidated at one point. So if there is a case, there's a lot of reasons just to join that case, including that the attachment procedure itself isn't necessarily required if it is properly done by the first party of the lawsuit. A little technical, a little legalese, but at least wanted to get it out there when we're talking about where do you file when you need to file a lawsuit to perfect the lien. Now, who do you need to put in the lawsuit? Who needs to be a defendant? Well, again, we're not suing individual people with a lien perfection action. We're actually suing the property, and we're trying to get clear title to that property. The only way you get clear title to the property is if that anyone who has an interest in the property is named as a defendant. So you've got to think really broadly. The statute that we started with a couple minutes ago, talking about what has to be done at the perfection of lien, has this language of person or persons whose interests the prime contractor seeks to attach and sell. So anyone with an interest in that property, you need to consider naming. And I would tell you there's a couple reasons for that. Number one, if you've got lenders out there that have an interest in the property, you've got to decide whether that lender is going to get the money from a sale of the property or whether it's going to go to the liener. And all that depends on priority. Two, if there's anyone else with liens on the property, you're going to have to determine priority amongst and between the lienors. And you can only do that if all the lienors are in the same lawsuit and named. Three, if you've got people with leasehold interest, if you only name the lessee, then the best you're going to get from a lien enforcement action is the sale of the leasehold estate, not the sale of the underlying property. So all of that said, think broadly when you're thinking about who you have to sue. And this is all consistent with what we talked about earlier with a number of the sections of the lien statute that require notice to the owner. And I flash back up on the screen here the definition of owner again. Owner being extremely broadly defined as anyone with any interest in the property whatsoever. So again, the requirement is the person or persons whose interest the prime contractor seeks to attach and sell. That's the black letter law that we're dealing with about as to whom you have to include in the lawsuit. But think broadly, think definition of owner here, think anybody that we need to get involved in the lawsuit to make sure that the title is clean when it sells. And the reason for that is the cleaner the title, the more money you're going to raise at a sale. The more money you raise at the sale, the more likely that you get paid on the lien that you're trying to perfect. All right. What do we have to include in the lawsuit? Well, first of all, I need to tell you that if you get to this point, you can go by yourself. I would strongly suggest counsel. But if you go by yourself, there is good news in the sense that Tennessee follows a liberal notice pleading standard, meaning that you don't have to put everything out there and it doesn't have to be perfect. But there are some things that are required, particularly in a lien setting. Number one, the statute requires you to set forth the basic facts. Now, what's really required there? Enough of a description that the court can see there's a contract, whether that's oral or written, that the contract involved an improvement, that you've got dates in there that show that you complied with all the different timing mechanisms we talked about along the way. And for remote contractors, the notice of non-payments were complied with. So we've got to have some very basic description that allows the court to see that you are at least saying, as the lienor trying to perfect a lien, that those items have been complied with along the way. Number two, we need a description of the real property. Again, there is not necessarily the need for a strict legal description. The lien statutes let us rely on what is in the building permit. Typically, a street address will be enough and should be enough in the vast majority of cases. If you've got the legal description, I always like to have that anyway in the notice of lien. You may as well attach that to your lawsuit just so you don't have any trouble on the describing the real property element. The other things you need are, you need a prayer for relief at the end, asking the court for what you really want, which is what you want is a sale of the property with the proceeds directed first to you to cover any lien amount that you prove is owed. Finally, and this is one that gets a lot of people, you have to file a lien perfection action under oath. And it's what's called a verified complaint. And that is typically not required for a garden variety lawsuit. For a lien perfection action, you actually have to have somebody that can swear that the details included in the complaint are true and correct, and put that under oath at the bottom in the verified complaint. That is one that a number of people overlook and forget whether a court will allow that to be cured if it's not done initially and not done until after a timing. One of the time, whether that's the 90 days to 1 year, have run is an open question. Don't be the one figuring out which way the court's going to go there. If you're putting the lawsuit together, you're taking the time to perfect all your rights, make sure that when you file the lawsuit, it is filed under oath. Now, just a side note here, while we're doing all this on perfecting our lien and filing it under oath, it doesn't mean that we're foreclosed from suing in contract and promissory estoppel and merit. Take your pick of what other causes of action that you want to be in the lawsuit. You can put whatever you want in there. You can plead an alternative to your lien claims. The fact is, you have to be a little bit more careful when you're dealing with what else you put in a lien lawsuit. And the reason I tell you that is because of the oath requirement, because you are going to have to verify that what's in the lawsuit is true and accurate from an individual's standpoint. And they're going to have to verify that anything else that is in there is true and accurate. And sometimes when you're pleading an alternative, it is very hard to marry those two concepts together. Now, let's see, do we have any questions today, Ariel?
So far, we do not have any questions. I think it's a lot of food for thought for everyone.
Well, that's great. I'll leave everyone again with this. On the perfection side that we hit today, make sure you know when the timing is and that you're watching for those tricks to shorten it. Make sure that when you're ready to move forward, that you're thinking both in terms of attachment and attachment bond, and that when you go to file your lawsuit, that you think about where you want to file it and that you go ahead and file it under oath. And with that, unless there are questions, I will thank everyone and look forward to seeing everyone in about a month.
Wonderful. And thank you again for an extremely informative webinar. And I hope you have an incredible day, everyone.